And thank you all for allowing me to speak today. It's an absolute pleasure to serve in this role. I came to the Arizona Association of Realtors back in January. And I come from the Arizona Commerce Authority, where I served as the Vice President of Government Affairs, leading the lobbying efforts for the state's Economic Development Agency. I feel at home in real estate. My mom was a property manager for years. My dad was a contractor and owned and managed some personal properties, and I assisted with all of that throughout my life. So it's something that's really I've personally invested in and appreciate the opportunity to serve in this role. It's been an exciting and topsy-turvy year to start a new position, but I think it's given me a lot of opportunities to prove myself and hopefully bring some wins that you all have been able to see in your day-to-day life. The legislative session was really chaotic. We had over 1,600 bills introduced and less than 100 were signed into law. And our legislative efforts were small on the offense. We were looking at one of our bills to expand the use of e-signatures, which we did get across the finish line. Another step to modernizing our industry, making sure that realtors, brokers, property managers, the real estate industry has the tools to succeed in the modern industry and the tech industry. And the other effort was allowing unlicensed individuals to collect rent payments. And that was one of our member bills that unfortunately needed an amendment, and we weren't able to get across the finish line as the legislature was dealing with the pandemic and recovery efforts. And so as those options became limited, we shifted our focus on what grew into a growing conversation around evictions and foreclosures and making sure that our message and our position was clear. We're a strong proponent for private property rights, private contracts, and communicated to the legislature and, more importantly, the governor's office as executive orders started rolling out. If you get assistance to the folks that need it, unnecessary evictions will not happen. And that was our loudly communicated position. The legislature appropriated $50 million. It could be used for eviction prevention. Through the CARES Act, there was another $128 million. And to date, the state has gotten out about $7 million in rental assistance. To put things in perspective, the city of San Antonio alone has awarded $33 million in assistance, and we are just far behind. I mentioned San Antonio because typically we like to look at comparable political landscapes. So you're talking about a red state, a predominantly Republican, metropolitan area, and it's something that we really feel has fallen on deaf ears at the executive level. We've communicated to Governor Ducey time and time again, eviction moratoriums are not the proper way to address this issue, that it doesn't allow folks the flexibility. I've communicated the unprecedented sense of community and, just human kindness that folks like you and property owners across the state have, exemplified in waiving late fees, offering payment plans, and spelling out how much work that really is. I know many of you have almost probably felt like you've turned into social workers, connecting folks with government, opportunities for assistance. And that's not the role of private industry in a state of emergency. And again, time and time again, we're left kind of scratching our heads as if we're not being heard. We've met with both Speaker Bowers at the State House of Representatives. We've met with President Fan, shared our frustrations there, and they stand with us. We have called for special sessions. The governor is currently not interested in that. And it's been really, really frustrating. I know that I've spoken to many of you on this issue, or folks within your staff. Sue Fluke's, one of your property managers, Dave Pruitt's been a great resource in giving me just real day-to-day, ground level viewpoints of what you guys are facing. Susan Creedon down in Tucson's been another great point of contact, and just hearing how, right after the CARES Act expired and that extra $600 of assistance dried up, we were immediately seeing folks contact their landlords, contact their property managers saying, I don't know if I can pay rent. And working with our contract lobbyist, Tom Farley, we continue to communicate how destitute do Arizonans have to prove themselves, either as a tenant or a property manager, to get assistance in this state. I tried to refrain from painting the most dire pictures because I believe that we had so much assistance dollars. I believe that the government was going to start mobilizing some of this, and the ineffectiveness, the red tape, the bureaucracy that we see day in and day out, when we see statistics like the fact that the city of Phoenix is releasing assistance dollars twice as fast as the state. We are constantly compounding our efforts, building our coalition, working with our friends at the Multi-Housing Association, NARPM, the Manufactured Housing Community Managers, and really trying to get the best network possible, because it's our position that, property owners are the only industry where the government is saying, you must continue to serve your customer. You can't remove your customer from your business. And if they don't pay, that's just on you and you have to eat it up. And after months of inaction, a coalition of us began developing a conversation around a lawsuit, which I won't get into too much because I know Denise Holliday's far smarter and well-versed and also invested in that conversation. But 2 weeks ago, a special action was filed in the Arizona Supreme Court. The named plaintiffs were among some property owners, Multi-Housing Association, and the Manufactured Community Managers. And we were a financial partner in that, although not a named plaintiff, due to our belief is that we didn't have as much standing, and we wanted the case to have the best standing possible, because as you've seen, lawsuits have started to pile up, and a number of them have gotten punted. This is for a number of reasons, some of them being political, some being, sensitive to the current pandemic, the nightclubs, the gyms, the water parks. But again, we continue to stand on the fact that this overreach is completely avoidable, completely unnecessary, and an abuse of powers. There's no stay-at-home order. There's no need to infringe upon private contracts. The inability to serve notice of non-renewals, forcing property managers and property owners to take long-term leases and move to month as they manage these properties is just appalling. And it's something that we're continuing to monitor closely. Our case is still, waiting to be fully decided at the Supreme Court level. The courts did make a decision not to move on the Barr's case yesterday, and it's something that we're hoping that they do take note of, because this is the biggest takings of private property in the history of the country. At the point in which you can't remove someone from your property, which you can't move back into your property, in which some cases I've heard, or you can't terminate a lease and ask your tenant to vacate the property so you can sell it. We have a strong real estate market. We have a lot of property owners that are interested in selling. And the fact that they can't do that is egregious at best. And so we've had strong legislative support. Our legislative leaders have issued a letter to Governor Ducey speaking to the policies that they supported, which were get assistance to those that need it, and that the policy of eviction moratoriums would not have passed their chambers. We were disappointed because the letter was not as explicit as we would have liked, but it did send a clear message. And we are being sensitive to the political landscape, the media landscape. We, have to be careful because it's easy for our opposition to sometimes paint landlords and property managers with a broad brush of folks just collecting a check. But there are utility bills, there are property taxes, there are things that need to get paid. This is income for some individuals and that don't necessarily qualify for PPP grants. And just continuing to hammer that fact every day, day in and day out, is something that it's my pleasure to do. I wish I didn't have to do it, but I will continue to represent you all in the industry that you guys work in until we see that this executive order is terminated. It's currently scheduled for October 31st, and which we communicated just in design, which we were notified 3 hours before it was released, how terrible that date alone is. And they said, the governor's office said, well, we thought it'd be good because it's right before rent is due. And so I am appalled at some of the misunderstanding or, resistance to hear the subject matter experts that I have put in the room with them, whether it be our CEO, Michelle Lynn, General Counsel Scott Drucker, folks like Denise Holliday. It is something that we will try to educate them the best we can. We will keep working with our stakeholders. I've been working with our GADs across the state to make sure that our local associations reach out to their networks, making sure that they're speaking to their local officials. Because some of our local municipalities, counties, cities are doing a better job, as I mentioned, with Phoenix and other parts in the state, of dispersing those assistance dollars, whether those be federal or direct federal dollars or federal dollars that have come through the executive branch. So I'm going to stop there. I have time for some questions before I have to jump off. But that is the long and the short. And I know Denise will dig in much deeper with the nitty gritty, but Tatiana, if you'd like, do you want me to just kind of pick some questions from the chat box, or how would you like me to do it?
We actually have 2 questions, so I can go ahead and read them for you.
Sure.
The first question says, so far as I understand, the landlord is not able to sell the rental property because the tenant is not paying rent. Should the landlord file bankruptcy or get foreclosed due to loss of income?
I would actually love to be connected with this individual, or Denise, I'm not sure if you were going to make that offer as well. I'd like to hear more about their story and see what I can find out as far as how much non-payment they faced. It's there is an avenue for for a bigger conversation. So if I could be connected with that person, I can put my email in the chat box, and feel free to reach out to me.
All right. And Denise, did you already answer that second question about the lease ending?
Yeah, I'll be covering that on my section, the technicalities about who can do what. But what he's saying really, guys, is really important. He plays a very unique role in our industry, and those kind of stories make a difference. And let me give you an example. When the governor changed his new executive order, although I thought he was going to not issue it at all, one of the things he did was he took away the issue about, hey, I might have COVID, I might have tested positive for COVID, I might think I know somebody who had COVID, and I have a health issue and you can't evict me. And what he did is he changed that. And he said, no more. You have to prove you have a financial issue. And I can tell you, we met with him 3 times saying, don't let this happen. This is what people are doing that are abusing that. And I think, at least on that sense, he heard. And so send those stories to Matt, because my impression is as we get closer to the holidays, I think they're going to do a holiday moratorium. And I think that's just devastating for our, a 9-month stay. Is just devastating. So those stories are so important. Please give them to Matt.
Well, and just to touch upon that, I believe that some of these decisions were made so short-sightedly. October 31st is, it's 3 days before the general election. So from a political standpoint, I'm not sure how a Republican governor is going to terminate a lease moratorium, an eviction moratorium 3 days before the election, when we have someone so drawn to polling, to the media viewpoint, and the Twitterverse, for lack of anything else. But so, yeah, I mean, we've come to that realization. It's very, very likely, unless we win this lawsuit, that we'll be seeing an eviction moratorium through the new year. And that is just appalling. We have taken private property and turned it into public housing at that point. And it's completely unacceptable.
All right, I think Matt has time for one more question. If someone wants to put that in the chat box, we'll give it a second before we start with Denise. So it says, I talked to a constable yesterday who said landlords can evict due to non-pay.
They can, again, there's a lot of gray area in the eviction, where they can serve, there's a few serving that writ, but it's our understanding that won't hold up in court because of the gray area that the governor has provided in his hardship under COVID. And we believe that those property owners will face an inability to evict. Becca, I'd love to talk to you more about that. But yeah, I haven't heard that from any constables thus far. So
yeah, I'll be actually presenting some of the stats because I just got them from the government. So we'll go through the actual stats, and I think you'll be surprised when you look at the total number of evictions that have happened from March to July. It's almost 7,000, which sounds huge, but normally there's 5,000 evictions every month. So in a normal market.
All right, so thank you so much, Matt. That's the last question we're going to take for Matt. So we're going to actually move on to.
And last thing, Tatiana, real quick, I have communicated that evictions aren't the goal in property management or property ownership. That there is a loss incurred with an eviction. There's TI improvements that have to happen. There's money that has to be spent. There's a lack of income that the property faces as there's changeover. So I have been very sensitive to remind them that, our goal, we're not in the eviction business. We're in the property management business. And it is a part of the business that's at the mayday, the sinking ship. It's not a point of success that we aim for. So thank you all for your time, and enjoy the rest of the presentation. Denise, I wish I could stay. I look forward to catching up soon.
Thanks.
Bye.
Okay, so I see quite a few different questions, and if it's okay for you, I'm going to throw up my PowerPoint real quick because I wanted to kind of walk through it in kind of a little more orderly fashion if that works with everybody. And here's the reason why is we really want to talk about this particular issue and what does it mean for you. And so just real quick, we're going to run through. I know we don't have a ton of time, so we'll go kind of quick. Then I'll do the questions at the end. So here's just my email addresses. And my email address and our two websites. This is what I want you to know specifically. Oops.
Denise, your
Yes?
PowerPoint's not up yet.
It's not. Well, thank you for saying that. Let's try this again. Let me tell my screen to share one more time. For some reason it didn't want to. Let's try it.
Now it's up.
Okay, let's do that again. Great. Thanks, everybody. So this is our website. We have our traditional one. I was talking to Matt earlier. I thought that was funny. I'm Doc Holliday. That's our family history. And so Dr. Victor seemed funny, but sometimes people think it's politically incorrect. So they send you both to the same website, by the way. There's not a ton on there about the COVID issues because they're moving so rapidly, but there's a section under hot news. So here's what I want you to really know about. This is the most important things. COVID has impacted multiple areas of your practice, and everybody is mad at you, including your owners and your tenants. And the problem is each of those goalposts just keep moving. And that, to me, somebody who's a rule follower, Sue and I, that's probably the one thing we have the most in common is we are rule bound. We will do whatever you say, but it has to be within the rules. And when you move them, it seems unfair. In fact, yesterday was a totally different day than about 3 hours ago. And we'll talk about what just happened 3 hours ago. And it's moving so quickly. I'm so glad that we've decided to do these basically every month because they really are moving so quickly. The only way you can answer questions is if you have this information. So same goals, right? Protect our staff members, everybody who works with us, including all of you, protect all of your residents, and protect the assets because we're worried about the lawsuits on the other side for potential somebody being infected, somebody who's an employee, somebody who's a vendor, but also the huge losses of money that our clients are experiencing. So part of it is just this, making sure you're on top of it. There are lots of waivers out there, lots of information. Understanding what's legal and what is not legal is going to be absolutely critical. So jumping in, first big executive order was 2020-12. I was so happy to learn that I am essential. Weren't you excited? I was so happy to learn I was essential. And then the world started moving so quickly that I am not joking, about every 2 or 3 days, the last 2 or 3 hours of the day, starting at like 4:45 until 8 o'clock at night, we were putting out memorandums to everybody as quickly as we can as things moved. And when we do that for all of our clients, and I know AAR was very busy and NARPM was busy, things just move so quickly, but real estate, you guys are all an essential service too. So then the next one, just a couple of orders later, and then it was modified in under Executive Order 49, really hit us with the blow. It basically said, if you have a non-payment of rent cases, the constable can refuse to do the lockout if the tenant alleges some specific things. That executive order was too broad. We repeatedly talked to the governor about it. He appeared to listen, but he didn't modify it for a very long period of time. By the way, this screen says some of our judges just decided that non-renewal notices may be covered by the executive order. They're requiring in our hearings that you give very specific information. I have a case right now where an owner is living in a hotel because their tenant hasn't moved out since July. And we're working on that, but the tenant filed an appeal. There's lots of ways that they can slow down the process. The court system, and I'm going to stop for a second. I'm going to take off my attorney hat, put on my judge hat. As many of you know, I'm a pro tem judge too. And they're moving just as quickly as we are in our field. About once a week, or at least once every other week, I'm on a Zoom call taking an additional class or teaching an additional class with all the new, what we call best practices or administrative orders coming down from the Supreme Court. And we've had multiple ones, I think a total of 9 that have been out in the last 3 months. And in the world of law, that's really fast. We just don't move that quick. So non-payment of rent cases can still go forward. Here's basically what the order did. It slowed down or delayed the writ, not the judgment, not the eviction, but the physical part of removing the tenant. Here are the circumstances listed in the first executive order. The person was quarantined because they tested positive. They were ordered to self-quarantine, not by themselves, but by a licensed doctor, key phrase right there, due to having symptoms. They are quarantined because of a household, somebody in the household broke out or tested positive. They have a health condition that was a higher risk. We had lots of people really abusing that. We actually had a 19-year-old who was still partying and working full-time and wasn't paying any rent, and she wasn't the leaseholder. She was just the daughter of a leaseholder, and a judge let her stay there for 5 months. Not because they couldn't afford their rent. She worked for the government. She worked for the state of Arizona, never lost her pay, but her daughter had that. And that's one of the reasons why the governor specifically changed his new order. The last one is kind of a mild one. It says they have to acknowledge in writing that the lease is still in place, and they still have to abide by all of that, even if they're not paying their rent. So he defined what lost income meant, and these are the categories: a job loss, reduction in compensation. See, that's so broad. We had somebody who was paying, they're a driver, and they were being paid 4 cents less a mile. Well, they technically qualified because it was a reduction in compensation, even though their spouse, who from time to time worked and was getting unemployment before all of this happened, and now she was making $800 a week. They didn't bring into this scenario or this analysis, what if you got stimulus money? What if you got unemployment money? Why don't you have to pay the landlord when now you have that? If your place of work was closed, if you had to work, stay at home because your kids, well, the summer happened like all summers happen, and lots of people stayed home with their kids because they were home with their kids anyway. And so that was something that needed to be cleaned up. And then the phrase other pertinent circumstances didn't give anybody any idea. It was basically whatever else the judge thought was appropriate. So lots of fussing and fighting about that. The new rules just went into place on Saturday, this last Saturday. The tenant now has to provide proof in writing to the landlord with copies of documentation. Even if they provided it in the past, it has to be updated. So it's something new about if they're working, something new about if they've applied for unemployment, something new about whatever those conditions are, those financial conditions. They have to request a payment plan. Well, we've been having tenants request payment plans. They owe $8,000. They want to pay $200 a month. We've been able to show that that's just not reasonable. This particular executive order didn't really talk about it had to be reasonable. It just said this is what the rule is. It also says they have to provide proof that they applied for rental assistance. I'm working closely with all the rental assistance agencies through the Department of Housing. The problem that we've had is in order to take that rental assistance, the landlord has to sign a form saying that you agree you won't evict the tenant for 30 days, but that you don't know how much money they're getting when you fill that out. That check is taking sometimes 60 or 90 days to even get to you. And then you have to wait another 30 days. So that's 120 days more than what they owe right now. And so some landlords are just saying, I'm not going to agree to that. The biggest change we saw was that any kind of virus-related issue or health-related issue is no longer in the discussion, which is interesting because I as an attorney, if somebody's tested positive, I'm not crazy about making them leave this house and go somewhere else. But the governor's position was, look, they can stay in this house, somebody else move all their furniture, and then they get in a car and drive there just as easy, which I agree with. So here are the two factors that the governor's order specifically says you're supposed to look at. It's a temporary circumstance, which means if they've already been on unemployment way before COVID hit, they don't qualify. And then what is the interest of justice? That is really what we're looking at right now and spending the most amount of our focus on. I want to give you some stats though. So these are important stats. They just came out. They're always a few weeks behind, so we'll be getting August here in about 2 weeks. In January through July of last year, there were 38,000 evictions. And that sounds like a lot, and we keep hearing in Arizona that we have more evictions than any other state. That is not true, because the real evictions in Arizona are what we call the lockouts, the writs of restitution. But in 2020, that number was down to 22,000. Now that doesn't sound like a big deal, but remember January, February, and March were really the same numbers. So it's only April, May, June, and July, 4 months, that created that big difference. They said a 42% decrease, but look at the numbers, guys. Look at May and June and July. Those numbers are going to reflect about $2 billion, with a B, $1 billion of loss of income with landlords in Arizona. That's what we're estimating. The writs of restitution of the lockouts, they were down 48%. Here's kind of going into the weeds. Executive order allowed for what we call motions to compel. A motion to compel is where a landlord says, hey, this person owes me money and I think they haven't provided the right documentation, or the interest of justice requires that you let me lock them out. And they have the burden to prove that. And here's what the stats say. These are the numbers. I was surprised that July was so low. I heard from the other attorneys in the industry. I'm the president of that organization, and they said they all waited to do the motions to compel until August because the governor's order was changing. So look at the real numbers. It's 240 total motions to compel, total, not just writs of restitution, but the total, hey, judge, do something about it, lock them out. Only 62%. So about, 1 in 4 were actually allowed to continue to stay. The CARES Act is still alive and well. Doesn't apply to us right now. So if you had somebody who had a mortgage that was covered by CARES, so it was federally backed mortgage or a Section 8 or some other subsidy, you weren't allowed to do a non-payment of rent case until now. You can file it now, but you couldn't just give them a regular 5-day. So if you have, immediately go on our website or go to AAR. Sue, I don't think AAR has a CARES right now. Okay, so go to our website. It's free. And it's basically what we're calling the 530. It tells them they have 5 days to pay, but you can't file it for 30 days. And all the courts are requiring that language to actually be on the notice. You could have served it as soon as July 26th. So if you haven't served it yet, you're kind of behind that for about a month. Also, you weren't allowed to do any non-renewals. You can now. You can issue a non-renewal notice now. Remember, today is the 26th. If you mail it today, you might have a problem. You have to get it 5 days before. So you go 27, 28, 29, 30, 31. First, okay, if you mail it today, certified mail, you can have them out at the end of September, but it would have to be mailed today. And I can tell you you're really tight on that number. Remember, no late fees from March 28th to July 25th. Do not file an eviction if it's covered by CARES, because there's a solid group of tenant advocates that are going and looking at every single lawsuit that's being filed. They're hoping to sue a number of landlords that either didn't know or lied, and they're looking for huge punitives. The advertisement I saw is they're looking between $50,000 and $100,000 as a punitive damage for filing on a CARES property when you weren't allowed to. So be super careful. This is a big deal. Other executive orders that impacted you, these are the biggest ones. The common area pools and gyms. Some of you do multi-housing. Heads up, you are the first ones to know. This just came out a few hours ago. Our Department of Health and Human Services said that pools, they already gave out some new rules, but the gyms specifically are no longer covered by this executive order. And there was another health order. They're not. You still have to put up signs and still have to put into place some sanitization methods and social distancing. But that complete ban, that huge hurdle that private gyms had to, they just told us today you don't have to do that anymore. So any of you who are doing multifamily, this is a big deal. Executive Order 52 basically said that all the other ones, those pools and gyms are still in place. They're going to analyze them every 2 weeks. New office policies, be careful, because if you have people coming to your office, make sure you've got office cleaning policies. My office is up and running, and every day at lunch, a crew comes in and they scour and sanitize the whole entire building. We do that twice a day because we're necessary service, and my fear is that someone will get sick and then would shut down potentially the whole office. The other thing is masks. You should require anyone coming into your office to wear a mask. Most cities have required this, especially around the valley. The failure to make sure that you properly sanitize and have protocol in place may create some liability. We believed that Congress was going to pass that. They are no longer in session, so they might pick it up in September. So watch that, because that's a fear why some people aren't opening now. Keeping really good records. We always have to keep good records, but here's the big key right now. Keep a record of, if you're asking someone to waive something, like you're going to show the property, or you're going to enter to do a maintenance request, or to use a common area, or to come into your office. Yes, you can use a waiver. Make sure an attorney looks at that, because there's some kind of special language you want to look at that. Be careful to monitor and write down why you're waiving some late fees for some tenants and not for others. So cares or non-cares, or this person's lost their job and they requested this owner's allowing it. Whatever you're doing differently, please take time and really document this, or you're going to have a problem as on a fair housing issue. And by the way, the fair housing cases have just gone absolutely crazy in the last 3 months. We're doing in the last 3 months what we've done in the last 2 years. That shows you how many cases are up. So really good documentation of why you treating different rental files differently. The big one we keep hearing is, my tenant won't let me in. We're trying to sell the property and they won't let me. The law has not changed. 33-13-43 says a tenant must allow you in for a reasonable time, reasonable period, frequency, and reasonable purpose. So it wouldn't be to maybe put a lockbox on there or do a showing, because they have the right to be afraid of COVID. But all you have to do is make sure everybody inside that unit who's going in the unit uses a mask and gloves. And then showing empty properties, move in, move out inspections, I can tell you those rules haven't changed. The only real law, and it's always been the law, is that if a tenant asks to be present during move out, you must tell them when you're going to do it. You don't have to set up a specific time that's convenient for them, but you have to notify them when it's going to happen, so they have the ability to show up, and you can require that they sign an inspection waiver that they agree to not be more than 6 feet from you. They agree to maybe even be in a different room. They agree to wear PPE, all of those things. And then can you ask them if they've been sick or anybody in the household? Absolutely. HIPAA does not apply to us. We're not healthcare providers. Just remember, put that documentation of whatever they tell you about having the virus or any of their health considerations like high blood pressure or whatever it is. Make sure that you put it somewhere separate in the file, just like you would already. Hopefully you already do. If someone's asking for a reasonable accommodation or a reasonable modification, right? I need an assistive animal. Here's my documentation that I'm disabled. That shouldn't be a regular part of the file. It should be something separate in a separate envelope. If it's electronic, have it a pass-coded envelope or a file so that not everybody else can see that information. Just remember, don't share that private information. That's always going to be a potential lawsuit. And that really is what I wanted to talk about. I know we've got a ton of questions, so I will stop sharing and let's see what questions everybody has.
The first question we had, Denise, are you willing to share your slides? We had a couple people interested in that.
Sure, absolutely.
So I will send that to everyone that registered later today. So the first question we have says, so can you charge late fees if they have not been affected by COVID?
So let's go backwards. The only people you cannot charge late fees was for that small period of time. That's a CARES covered period of time on a CARES covered property. Everyone else, there's never been a prohibition on late fees. Now the governor put out guidance that he asked landlords to waive those late fees. It's never been mandatory, only for CARES covered properties and only during that CARES covered period of time.
All right, thank you. The next question says, what about the moved out homes and cleaning them?
So I think that you need to make sure that your cleaning people are doing an extra set of cleaning or sanitizing steps, and that they're putting in writing what they're doing with you. Otherwise, you're really going to need to leave that house empty for about 3 days just to ensure that there's not going to be potentially any leftover viruses, including if the tenant told you that they have some kind of some symptoms or they tested positive.
All right. We just got another question. Can you still file for an eviction if the tenant is on a fixed income but it is not affected by COVID?
Okay, remember, yes, you can, all tenants, you can still file evictions. And while I understand the belief that we really don't want to continue to evict people if they're trying to work with you, being an attorney, I look at that a little bit different. If they skip out and move before you get a judgment, it's really hard to collect that. So if they haven't been paying the rent, issue that non-payment of rent notice. If they don't come up with the full amount, then go to court and get the eviction. Now, at that point, I want you to think about slowing down. Once you get the judgment, your owner's in a much better position because now you're really in the driver's seat. So the tenant's been sending you all the documentation, yes, but that doesn't stop the judgment. We need that judgment to protect our owner. So after they've giving the documentation either before court or after court, once you have the judgment, I really want you to slow down and think about what will the judge potentially do with this information the tenant's given me. So if they show that they've been impacted by COVID, any of those reasons, you really need to sit down and work out a good partial payment plan. If they have money coming in from the city or from any of the agencies, you want to include that in your partial payment plan. The first line, money from the Department of Housing. How much? Put it in there. When it's supposed to be paid? Unknown at this time because that money could take weeks or days, but it's guaranteed money. So put that in as a payment. And then what else is the balance and what is the tenant going to do? Are they going to keep current on the first of all the future rent? Are they going to pay $200 every week, $500? Really, your job is to enter into a partial payment plan, which many of you have never done. If you refuse to do that, I can tell you, you will not win a motion to compel. The reason why I think that our firm has been pretty successful, we've lost, I think, a total of 13, and we've done about 130, maybe 140 now. And those are, we work really hard to get the information from the tenant to try to get them to sign anything. So I really encourage you to try to do the best you can to get a partial payment agreement. And if they don't pay that, then we go to court and say, Judge, we worked with them, we gave them some information, and they won't pay us. And I see this question from Randy. If a tenant does not pay because they've lost hours, when they move out and they don't pay, can you send to collections? Yes, but I would encourage you. You can't file the eviction if you already get possession. If you have the keys back, you just can't. That's the way it works. But if you file the eviction now as quickly as you can, if the tenant turns in the keys before the day of court, you still need to keep that judgment in place. The judgment is what's protecting that owner. That judgment is good for 10 years and can be renewed forever. And so you really need to have the judgment in place because that's what's going to protect your owner. And that's really what's going to protect their rights for additional, to be able to show that the tenant was in breach and they had additional charges. So the constable said a landlord can evict a non-payment, and you just saw the numbers. Yes, they absolutely can evict for non-payment. They can get a judgment, and they can even potentially do the lockout depending on the information the tenant provides. I saw back here somebody said a tenant moved out, but they won't give the keys. Yeah, if they haven't paid the rent and they haven't returned keys, you have the right to do a notice of abandonment if the rent is owed for 10 days and the stuff is still there. And the abandonment notice says, hey, we're going to deem this as abandoned. If they say, no, I haven't abandoned, then go evict them because they still have keys. Go get a money judgment for the money they owe you for the rent because they can't just hold the home hostage. Let's see, is any more up there that I miss?
Yes, so we'll take about 3 more questions. Let's see what we have. It says, took over rental from owner, self-managed, but under market rate. Market rate increase may be more than long-term tenant can afford. Suggestion, rule, question mark.
So interesting, Arizona, we don't have any rules about your ability to increase the rent. You have the right as a property owner, the property manager, to increase the rent to market rents. Not sure this is the best time, but I do have clients that have decided that they're going to increase the rents. They've also decided they're going to make it harder for people to move in. Be careful. We see a lot of people trying to move in and their source of income is unemployment. That's not a source of income. That's a temporary benefit. And so you wouldn't use that as a source of income. But if they can't afford that increase, Remember that some of our judges, and I would say probably a third of our judges, think that if you non-renew them, or even if they non-renew because they can't afford the new higher rent, they might get some additional time to move out. You will get a judgment for a holdover, but the court may give them a little extra time to find a place to move.
Okay, we have one that says, what should you do if the tenant calls and the air is out, but they have been exposed to COVID? How should we handle that?
Yeah, it's been a really, really long, hot summer. And one of the things that we have found is that a lot of vendors are not willing to go into homes where someone says they've tested positive. And the reality of it is the landlord's duty to provide essential services has not changed. It is not impacted. You still have to provide all health and safety services. You don't have to do the cosmetic stuff, but you got to do everything else. So you would still need to send somebody in. You can require that that the person who tests positive or who's been exposed is in another room. You can wear protective gear. We've discovered through a lot of different tests that just because you're in the room with them doesn't mean you're going to catch anything. So you wear gloves, and remember, when we put on a glove, we take it off carefully where we pull it through so that it's backwards, and then we dispose of it. The same thing with the mask. If you're going in and you're doing the actual work, you want a disposable mask where you don't touch the inside. They use a different one for every single home. And most of our vendors, especially the reputable vendors, already know that. But we tend to see a worse problem with our warranty work. It seems like we're having a bigger problem getting some of the warranty work done using COVID as an excuse, but the law has not changed.
It says, once eviction is filed but before court date, if the tenant shows up with rent but not the full amount, including court fees and attorney fees, and you send them away, what will the court tend to do at the hearing?
Okay, so if they come up with part of it but not all of it, you can have them sign a partial payment non-waiver that you're accepting this money but you're not waiving your right to get the judgment, and that you won't get the writ until and unless they pay the balance. We have that form on our website. It's called a partial payment non-waiver form. It is number B as in boy, number 2. It also says, in the event we've already gone to court or we already have a court date, we're not waiving our rights under the law. But you should absolutely have them sign something. Don't take any money, or say, look, I'll take it after court, but at this point it's not enough. Come and talk to me after court. Let's set up a payment arrangement after court. By the way, if they send it to you, mail it to you, drop it off, if you keep it more than a couple of days, then you have accepted it and you've waived your owner's rights. We also have a form on the website called rejection of a partial payment, and you should send it to them, certified mail it, and say, I can't accept it because you didn't come in and sign a payment arrangement. But don't keep it, don't deposit it, and remember, under ADR rules, you don't have the right to just stick it inside a safe. You have to deposit that money, right? So send it back.
Okay, and then we'll just answer these 2 final questions before we wrap up. What if the tenants are Canadians and left the property rental?
Okay, so regardless what their nationality is or whatever their circumstances, if a tenant has physically left the property and not returned the keys, and either left items behind or skipped out and took everything, but you don't have keys, you can process them through what's called a notice of abandonment. We have a special statute, 331370, and what it says is if you haven't heard from the tenant and they still owe rent, so that's a key, then you post a notice of abandonment on the front door. This is the tricky part, so pay close attention. You post it on the front door, you mail it certified mail, and here's the kicker, you have to mail it certified mail, return receipt requested to all known addresses. That's a very rare thing, and under abandonment, you have to do it 2 times. You have to do it when you do the notice of abandonment, which means it might be email, right? That's a known address. It might be the employer. It might be an emergency contact. And then the second part of that is after you've waited that 5 days, remember, it's no extra time for mailing, so 5 straight calendar days starting the day after you post and mail it properly. Then there's if stuff's left behind, then you have to send out what's called location of abandoned property notice. And that means you have to store that property for 14 days. And that notice has to be sent the same way, certified mail, return receipt requested to all known addresses. But there's a way to get the property back. If it's completely empty, be careful. If you just go in and rekey it because it looked empty, the tenant could say you illegally ousted me, which means you're going to owe them many, many thousands of dollars because I was coming back to clean it, or I left something in the attic, or that chair that I left outside was my great-grandmother's and it meant something to me. So be careful about just retaking property without going through the right steps.
All right, so this is the final question for today that we're going to take. It says, I have done the abandonment notice. I did have him sign back in March on the 5-day notice. Do I need to create a new 5-day notice?
So if you did a notice of abandonment, those are two separate steps. So if you have somebody who hasn't paid rent, then you would proceed against them under a 5-day non-pay, right? A notice of abandonment is when they're physically gone from the property. So if you haven't heard anything from the tenant, then they might be gone. So either serve them a 5-day non-pay and get an eviction judgment against them, or if they're gone, or you're pretty sure they're gone, you can tell that because there's no electricity and there's no cars and there's no movement. If that's happening, that's truly a notice of abandonment. If you gave one and they came back and said, no, I'm not quite done yet, but now you haven't heard anything again and the rent's still due and owing, yes, you'd have to start that process again. I saw something here about somebody having a question about a deposit. Let me ask what that question was.
Denise,
Uh-huh.
that question is, what if the tenant deposited, or it just moved, deposited
Partial
directly
payment
into
to
their
their
bank
bank
account?
So that's why we don't like that, because they can. There's actually a really good case that says if just because a tenant deposits that money, it's not like a game of hot potato, you know, who touched it last. If it's not the right amount, the landlord can now write a check and send it back to them. Be careful, because if they deposit the money and then it's reversed, you just paid them to be your tenant. So be very careful about that.
All right.
Anything else?
I think we are good.
Denise,
Thank you.
I had one question that I really wanted, because I had a property manager actually test positive. Does she then have to notify tenants that she came into contact with?
Great question. The answer is no. You probably have come in contact with lots of people at the grocery store and all other kinds of places. If it's multifamily, you would send out a notice that someone who had contact with the property has tested positive and reminding everybody to do something, but you don't have a separate, what we call disclosure issue. Real quick, just we didn't talk much about it, but on a heads up on that special action case, what happened is there's numerous landlords that sued the judges and the constables and the governor. And that case is proceeding. We probably won't know for a number of more weeks whether or not the Supreme Court's going to even accept jurisdiction. We really don't have any idea whether they're going to take it at all. So there's not much you can do at this point, except for just kind of watch that. We anticipate knowing something in weeks, but at this point, the case is just kind of sitting there.